I'm Ben Meiselas from the MeidasTouch Network, and this is a breaking news alert. Another loss for Donald Trump in court today, this time in connection with the New York Attorney General, Letitia James's $250 million fraud lawsuit against Donald Trump, the Trump Organization, Trump's adult children, for fraudulent valuations, inflated net worths, ultimately to gain improper benefits from tax assessors, insurers, and lenders. This lawsuit by Letitia James was filed back on September 21st. She filed a notice of related case to the special proceeding that she was pursuing for many years before the lawsuit was initiating. And you'll recall the special proceeding is a device that the New York Attorney Generals can pursue by statute, where they could get discovery into individuals engaged in improper real estate transactions and other improper business transactions. In connection with those special proceedings, Donald Trump was held in contempt of court for not turning over records. He was then ordered to pay a $100,000 plus fine and eventually turn over records. And in addition, Donald Trump was ordered to sit for deposition, where he took the Fifth Amendment over 400 times. The judge presiding over the special proceeding was Justice Arthur Engoron, and Justice Arthur Engoron was someone who Donald Trump did not want to be the judge of the current civil lawsuit. And when New York Attorney General Letitia James filed the current case on September 21st, she filed what's called a notice of related case to say Justice Engoron was the same judge overseeing the special proceedings. In the interest of judicial efficiency, Justice Engoron should oversee this lawsuit as well. Even though Donald Trump was evading service of process, he did not want to be served. His lawyers were ignoring attempts by New York Attorney General Letitia James' office to serve Donald Trump. His lawyer, Alina Habba, and other lawyers for some of his adult children were hard at work applying or filing these letter briefs with the New York State administrative judge who oversees how cases are ultimately distributed and whether cases belong in different departments. But they filed a letter saying Justice Engoron should not be the judge of this case, that Justice Engoron should not be the judge, and instead the case should go before what's called the commercial division, because the factors relating to Letitia James's lawsuit, the fact that it's a complex business dispute for hundreds of millions of dollars, would normally fit the criteria of a commercial division dispute. But in reality, what Donald Trump wanted was to not be in front of Justice Engoron, who knows all about Donald Trump's fraud, who has experience dealing with Donald Trump's delay tactics, who has ordered Donald Trump to show up for a deposition, who has found Donald Trump previously in contempt. Trump did not want this case before Justice Engoron. His lawyers did everything to try to resist, and so they filed a motion to have the case be heard in the commercial division. And the commercial division in the New York court system, by the way, is a very fair, it probably would be a respected judge who would do a good job. But by transferring it to the commercial division, Donald Trump likely would have been able to delay this case, not just for years, but possibly a decade. I've had cases in the New York court system. It's weird. The New York's lowest court is called the Supreme Court. The highest court is the Court of Appeal. And in New York, in these business litigations, you could basically appeal almost any order from the Supreme Court up to the Court of Appeal and through the intermediary courts. And these rulings just take forever. So the big move that Donald Trump was trying to make here was delay, get this case outside and away from a judge who knows his tricks, get this case removed from Justice Arthur Engoron, and get it moved to another court. denied. The motion was denied by the court's administrative judge in an administrative order. In this order by Adam Silvera, administrative judge for civil matters. First, in this order, one of the things that Judge Silvera said was, and made note of, Trump, you all were basically avoiding service of process, but you had your lawyers then send these letter briefs to remove Justice Engoron and transfer it to the New York's commercial division. So you shouldn't have done that until you accepted service. You can't have your cake and eat it too, avoid service, but then make appearances and file these letter briefs to get the case removed. And then in any event, what the court finds is that in its final ruling on the last page, it says, consistent with court procedure, the general clerk's office appropriately assigned this action to Judge Engoron on grounds that plaintiff identified it as related to the special proceeding. In the event Judge Engoron deems this action unrelated to the special proceeding, pursuant to a certain section of the Commercial Division Code, Judge Engoron may make the request to transfer this action to the Commercial Division. Contrary to counsel's assertion, the special proceeding is still pending before Judge Engoron and has not been marked as disposed. And then the ruling finishes. Accordingly, the letter application seeking an administrative order transferring this matter to the commercial division is denied. That is, Trump's letter application seeking an administrative order to transfer this away from Justice Engoron to the commercial division is denied, and the action shall remain before the Honorable Arthur F. Engoron, a general individual assignment part of the court, as a related action for a judicial economy and expediency. And those last words, I think, are very important in the order. Judicial economy and expediency. If those words are the antithesis of what Donald Trump wants, judicial economy and expediency. One of the things that New York Attorney General Letitia James has already asked Justice Engoron for already is that trial be heard in 2023. Judicial economy and expediency. Expediency. We don't need this case to go and last till 2030 or 2025 even. We need this case heard in 2023. And Justice Engoron, you've seen all of the evidence already. You've seen what's transpired in the depositions. You know that Donald Trump has asserted the Fifth Amendment. You know that Alan Weisselberg asserted the Fifth Amendment. You know Eric Trump asserted the Fifth Amendment. You know the issues at play here. There should be no delays. Let us set a trial date and let's go. Judicial economy and expediency. One of the other important things to note about what's gone on here as well is that Letitia James, the New York Attorney General, has also recently, within the past 2 weeks, filed a motion for preliminary injunction requesting that the court appoint an independent monitor, kind of like a special master in an ironic twist, an independent monitor, though, who would literally sit there at Trump Tower and oversee all of Donald Trump's financial filings and financial representations on a going forward basis, as Letitia James has asserted that Donald Trump is engaged in ongoing and current criminal conduct where an independent monitor is needed to observe that conduct, to prepare reports for the court, to ensure that false representations are not made on a going forward basis, and to also ensure that fraudulent conveyances of assets are not occurring from the Trump organization to affiliated entities. One of the things in the motion for preliminary injunction order that Letitia James points out is that on September 21st, when she filed the $250 million fraud lawsuit, Donald Trump created a new company in Delaware that was called Trump Organization 2. So Attorney General Letitia James says we need to make sure that he's not transferring assets from Trump Organization 1 to Trump Organization number 2, or fraudulently conveying assets to other third-party entities that are affiliated to avoid a disgorgement order or the return of the $250 million at least that the state alleges Donald Trump wrongfully took through his fraudulent valuation schemes. That is being heard by, you guessed it, Justice Engoron. Justice Engoron, who's now the judge for sure of all of these proceedings, and Justice Engoron has set an expedited briefing schedule where oral arguments will be held on October 31st. Justice Engoron has ordered that Donald Trump respond very quickly to the preliminary injunction motion for full oral argument to be heard on October 31st. And at that point in time, Justice Engoron will make a ruling about whether a preliminary injunction will be granted, in which case an independent monitor would be appointed, sitting right there looking over Donald Trump's shoulder or his accountant's shoulder as they're doing their financials, looking at every single email, every single paper that they're filing in real time. In many ways, when you think about it, if the independent monitor is granted, that would be like one of Donald Trump's worst nightmares, as he engages in his financial chicanery and his trickery and all of the things that he's doing. The last thing he wants is a financial monitor that's looking over his shoulders to see all of those communications with foreign governments and to all the shady lenders that he has to deal with. That is exactly what would happen. That is why, though, Trump wanted desperately, I can't stress it enough, desperately to get this case away from Justice Engoron and into the commercial division. As I said earlier in this video, the judge who he would have got at the commercial division, very well-respected judges in New York in the commercial division, they would not tolerate his nonsense. But remember that order, judicial economy and expediency would likely not be the result in the commercial division. You'd be probably talking about there's a huge backlog there. Cases take a really long time. By the way, cases take a long time in the general courts as well, where Justice Engoron sits, so I don't want to act like those are like super quick courts, but this case has already made its way through many years of litigation before Justice Engoron through the special proceeding. So Justice Engoron understands all of the issues, and so you don't have to start over again from the beginning. That's why this order, while maybe it's seemingly being reported as something minor or Trump, not getting the judge he wanted, it has real massive implications, and that's why we break it down in this way for you, so you understand how devastating it is to Trump that Justice Arthur Engoron will be the judge overseeing his case, and what that entails and what that means, that there will likely be a trial, I think, in 2023 regarding Letitia James' $250 million fraud allegations against Donald Trump, which, by the way, would also have the effect of stopping Donald Trump from further engaging in business in New York or serving as an officer or director on companies. It would essentially be the death knell to the Trump organization, certainly doing business ever again in New York, but potentially everywhere if Letitia James prevails in this lawsuit. And ultimately, what do I think will happen with the lawsuit? There's lots of people who say a case like involving valuations or valuations of properties and what representations are made to bankers, where there's all this disclaimer language, is very difficult to prove. And my point is, in this specific case, though, I think Letitia James is going to have an easier job proving these allegations, specifically because Donald Trump, Eric Trump, Alan Weisselberg, the CFO, have all asserted their Fifth Amendment rights against self-incrimination. And in a civil case, Unlike in a criminal case, asserting the Fifth Amendment in a civil case results in what's called an adverse inference, meaning a judge or a jury who hears the case can assume that based on the assertion of the Fifth Amendment, that the reason the individual is not responding to the question and asserting the Fifth is because the information would be damaging to them. You can infer, as a jury or a judge, an adverse finding against the person who asserts the Fifth in a civil case, because in a civil case, your life and liberty are not in the line. In a criminal case, you can never call up a witness who asserts the Fifth and then tell the jury, hey, look, he asserts the Fifth, or she asserts the Fifth, or they assert the Fifth. They must be guilty. You can't even make an argument to the jury, hey, the reason that the defendant didn't testify is because they're asserting the Fifth Amendment. You know what they must be hiding. You can't do that in a criminal case. In a civil case where money is on the line and it involves business disputes, you can absolutely do that when someone asserts the Fifth. That's why I think Letitia James is going to have an easier job proving this case and succeeding in this case, in addition to all of the facts that I think are very favorable. But look, this is a case, if Donald Trump stood by the numbers and his valuations when he was deposed by Letitia James a few months back and he pled the Fifth over 400 times, why would you not just say, yeah, the property's this valuable? Sure, Mar-a-Lago's worth this. Yeah, Trump Tower's worth $1 billion and this is worth $5 billion or $10 billion. These assets, this is what they're worth. And yeah, sometimes that the values change depending on market conditions, but these are very valuable properties. He didn't do that. He didn't do that. Letitia James is going to say because he was guilty, he was liable. You could infer his wrongdoing, make that adverse finding. So that's your update on everything that's going on in the Attorney General's lawsuit in New York against Donald Trump. I'm Ben Meiselas from the MeidasTouch Network. Hey, hit the subscribe button right now. It is free to subscribe, so hit the subscribe button. I don't know what you're doing if you're not subscribed to the MeidasTouch Network and you watch these videos. Also, if you want to help grow this network, and I always get asked, what can you do to help grow this network? No matter where you are in the world, you can help out. And here's how you can help out. Go to patreon.com/MeidasTouch. patreon.com/MeidasTouch. There are different membership tiers there where you can get exclusive content, exclusive podcasts, exclusive posts, exclusive question and answer sessions with me and my brothers. There's one tier where you could even become an honorary producer of the MeidasTouch podcast, and your name appears at the end of the podcast episodes, and you'll get a poster. Other tiers where you'll get postcards from my brothers and myself, but lots of content there. But most important, we're not funded by any outside investors at all. Zero. We're 100% independent because we're powered by democracy and fueled by you. So to me, most importantly, sure, you get those added perks if you join patreon.com/MeidasTouch, but wherever you are, if you want to help grow this, because you're like, hey, I watch your videos every day, I share your videos every day, what can I do to help and just be a part of it, even if it's a small part of it? There is no small part or big part. We're all in this together. And the way you can help out, go to patreon.com/MeidasTouch. Until next time, I am Ben Meiselas.
At MeidasTouch, we are unapologetically pro-democracy, and we demand justice and accountability. That's why we're spreading our message to Convict 45. That's right, gear up right now with your Convict 45 tees and pins at store.MeidasTouch.com. That's store.MeidasTouch.com.